Hello and welcome to today's webinar, Using Options in Development Transactions on behalf of Legal Futures. My name is Peter Dollar and I'm going to be presenting this webinar today. I'm now a full-time freelance lecturer, trainer and writer, but I spent practically the whole of my 25 years in practice specialising in development work, and I did literally hundreds of option agreements. So this is absolutely my bag today to talk about. Option agreements are always popular with developers. From the developer's point of view, the grantee of the option, they're a very flexible way of acquiring and in particular assembling a development site. Having said that, there are many traps for those acting both on behalf of landowners and on behalf of developers, as recent cases have demonstrated, and I'm going to be looking at the main issues today when acting for both landowners and for developers, including option land. Should the developer be able to acquire the whole or part only of the option land? And there are issues for the landowner where part only can be acquired. Planning issues, in particular, how do you define planning permission? Section 106 planning obligations, issues for landowners and for developers. Defining and extending the longstop date. The purchase price, if the option is actually exercised. Forms of notice and methods of service of option notices. Complying with Section 2 of the Law of Property Miscellaneous Provisions Act 1989. Registration of options at the Land Registry. And lessons from recent cases, and I'm going to be mentioning in particular Fishbourne Developments Limited against Stevens, Retirement Villages Developments Limited against Punch Partnerships, and also Hush Brasseries, which is a very unusual case, not particularly focused on development, but there are issues for development that can arise out of the case.